Hello and welcome to the Estate Planning Toolbox. Thanks for taking some time out of your day to check out everything we have going on here. My name is John Connor and I am an attorney in the Trust and Estates Group of Graves, Doherty, Heron & Moody, a law firm located in downtown Austin, Texas. This podcast is a client-focused podcast covering various estate planning topics including wills and trusts, powers of attorney, corporate entities such as LLCs and limited partnerships, probate administration, and everything in between. Thanks very much for stopping by. Hello everyone and welcome back to this week's episode of the Estate Planning Toolbox. Today we're going to be continuing our discussion of the Texas Probate Process. We'll be talking about the hearing to have the will admitted to probate, as well as some of the initial steps the executor could take once they are appointed, and we'll also talk about the deadlines that the executor needs to be aware of. But before we get started, here is today's movie quote of the day.
This is Houston. Say again, please.
Houston, we have a problem.
Pretty short quote there, and as always, if you don't know what movie it's from, stick around until the end of the podcast and I will reveal the answer. So looking now at today's topic, once you have met with and engaged your attorney to represent you as the executor, the next thing that you need to do is actually have the will admitted to probate. The first thing that your attorney will do is they will have the original will filed in the probate court along with an application for probate. It's in that application that they ask the court to make findings of certain things regarding the decedent, the decedent's will, and of course to appoint you as the independent executor of the decedent's estate. Once the will and the application have both been filed with the court, your attorney will then coordinate with you and the court in order to set up a day and time to have the hearing to have the will admitted to probate. The hearing itself is not too complicated. It's nothing at all like you see on TV with juries and surprise witnesses. It's a very short hearing in front of the judge, 5 minutes or less, and in all honesty, probably 2 minutes or less, in which you and your attorney will walk through some testimony known as proof of death testimony. I myself type up this testimony ahead of time and I word each of the questions so that the answer to each of them is yes. That way the person giving the testimony doesn't have anything to memorize and will help things move a little bit smoother. At the hearing, the judge will most likely admit the will to probate and will then issue letters testamentary. As we'll talk about, it's those letters testamentary that give the executor the authority to act on behalf of the estate. Also at the hearing, you as the executor will sign the proof of death testimony that you gave to the judge, and you will also sign the oath of independent executor. Now, you should be able to get letters testamentary at the hearing or at least very quickly thereafter. And at that point, the executor is off and running. As I just mentioned, it's the letters testamentary that give the executor the authority to act on behalf of the estate. Very often, banks, financial institutions, anyone you're working with to transfer property, be that real property or personal property, is going to ask to see a letters testamentary. They may accept a copy or they may want an original. And it's that letters testamentary that lets them know that you are the individual that has the authority to act and transact on behalf of the estate. Also, after the hearing, be sure to get a tax identification number or EIN for the estate so that you can go and open up a bank account in the name of the estate. Once you have those letters testamentary and you're off and running, you do want to be sure that you are aware of a few deadlines. Generally speaking, there are 3 deadlines that the independent executor needs to be aware of. Now, one thing to keep in mind with each of these deadlines is that the clock doesn't actually start ticking on them until letters testamentary are actually issued. It doesn't start from the hearing date or any other date. It only starts once the letters testamentary are officially issued. Additionally, these are deadlines that your attorney really should be helping you with. These aren't anything you should be off doing on your own. The first deadline to be aware of is the 30-day deadline for notice to creditors. And how you meet that deadline is by filing a notice to creditors in a paper of general circulation in the county in which the decedent died. Again, that's something that your attorney should prepare and get published in that paper of general circulation. Sometime thereafter, but there's no deadline on this, the publication will actually provide your attorney with a publisher's affidavit, which your attorney will then file with the court, showing that you met the 30-day notice to creditors deadline. The next deadline to be aware of is the 60-day notice to beneficiaries deadline. In this case, your attorney will prepare letters and will send those letters along with a copy of the will and a copy of the order admitting the will to probate to the beneficiaries of the decedent's estate, certified mail return receipt requested. Thereafter, your attorney will prepare and file an attorney certificate stating that they have notified all the necessary necessary beneficiaries of the estate and have provided them with the letter and the copy of the will and the order. This attorney certificate, though, is not actually due until 90 days after you've been appointed as executor, but again, this is something your attorney will need to do on your behalf and not something you should be doing on your own. Finally, and this is the big one, the one that everyone kind of talks about, there's a 90-day deadline for preparing and filing an inventory of the decedent's estate. The 90-day deadline for the inventory is not necessarily hard and fast. It can be extended, but that's up to the judge as to how far they will let you extend it out. Sometimes they'll extend it 30 days or 60 days, maybe up to 6 months, or if you're filing an estate tax return, they may match the filing of the inventory along with the filing of an estate tax return. So that could be potentially 9 months after date of death plus an additional 6 months on top of that. So maybe 15 months after actual date of death. So the inventory itself is actually called the Inventory, Appraisement, and List of Claims. And what this is an inventory of the decedent's assets as of the date of their death. Not of the date the will was filed or the date that the will was admitted to probate, but as of the decedent's date of death. Now it says appraisement in the title of this document, but appraisers may not be necessary. That's going to depend a lot on the assets you have, the size of the estate, and it's something you'll need to discuss with your attorney. Finally, there's this part about the list of claims. It's important to understand that this is referring to claims that are payable to the estate, so amounts that were owed to the decedent as of the date of death. It is not referring to claims that are payable by the estate, so it's not referring to anything having to do with the decedent's creditors or the creditors of the decedent's estate. It's also important to understand that the inventory is only going to include assets that pass pursuant to the decedent's will. Assets that pass by beneficiary designation, pay on death designation, or by a right of survivorship will not be included on the inventory. Generally speaking, what you need to include on the inventory is real property located in the state of Texas and all personal property no matter where it's located. So if the decedent owned real property that was not located in Texas, that is not something that will need to be included on the inventory. Similarly, you generally won't have to include IRAs, 401ks, or life insurance policies unless those are payable to the estate. If they have some other beneficiary designation, then they will not be included on the inventory. Additionally, bank accounts or brokerage accounts that are owned with a right of survivorship will not be included on the inventory. Only those assets that pass pursuant to the decedent's will and the terms of that will be included on the inventory. So that will do it for today's discussion of part 2 of the Texas probate process. Next time we'll discuss actually administering the estate, taking care of paying creditors, paying taxes and other expenses, and of course we'll talk about the part that the beneficiaries are always worried about, the finalizing and distributing of the decedent's estate. So be sure to check back in soon for the next part of our series on the Texas probate process. Before we go though, here is today's movie quote of the day, and it is from Apollo 13.
This is Houston. Say again, please.
Houston, we have a problem.
Well, thanks everyone for stopping by today to check out this week's episode of the Estate Planning Toolbox, and be sure to check back in soon for our next podcast.